I'm going to introduce Dr. Baumer now, our last witness. Dr. Baumer is a professor of law and technology at North Carolina State University, which I was just there about a week ago, in Raleigh, North Carolina. Dr. Baumer has written extensively on the security and privacy of electronic medical records, as well as legal liability in the information age. He received his BA from Ohio University, his JD from University of Miami, and his PhD from the University of Virginia. Welcome, Dr. Baumer, and you have 5 minutes for your testimony, and I will be equally as lenient with you.
There we go. Thank you very much. It's a pleasure to be here. Actually, it's a pleasure and an honor to address the House Subcommittee on Healthcare and Technology with Congresswoman Renee Elmers and Congressman Richmond. I am the head of the Business Management Department at NCSU. I have a PhD in economics and a law degree. I've been a member of the bar for 31 years. And within the field of law and technology, I have examined security and privacy issues. My work has been published in economic, engineering, accounting, and law reviews, but enough bragging. I delivered this speech to my wife, and she said, "Tell them what you're going to talk about, and then get to it." So let me just say that I believe the written statement that I provide outside fills in a lot of the gaps relative to this PowerPoint presentation. However, my recommendations, to get right to the point, are that small healthcare firms should be provided with safe harbors in the form of EHR software that insulates them from suit by the Federal Trade Commission, by private class actions, and by state attorney generals. Secondly, currently there is no private right of action under HIPAA, nor should there be. Third, small healthcare providers should not have to be IT specialists aware of the latest techniques in combating identity thieves. And fourth, a step in the right direction, and I'm gratified to hear this discussion, is certified software under ARRA, which creates, I would hope, a due diligence defense if somehow a cyber break-in occurs. So finally, I would like to point out that removing legal uncertainty, as we have seen, will not result in widespread adoption of EHR unless other obstacles are dealt with, including startup costs and interoperability. However, going back to some of the work that I've done, I've worked with people at Carnegie Mellon, Virginia Tech, Georgia Tech, examining FTC interventions on behalf of citizens, privacy, and security. And the FTC has done a very good job. They are dealing with some very clever people, but what we have found and what we have discussed in the FTC's interventions is that the FTC standards for commercially reasonable security evolves from case to case. And that's because the IT technology continues to evolve. So encryption, people talk about encryption. 40-point encryption is no longer state-of-the-art. It's now up to 130, and it could be higher. So these interventions by the FTC create uncertainty, in my opinion, even among large firms, but certainly small firms are overwhelmed. In 2004, I wrote an article, co-wrote Internet Privacy Law, a comparison between the United States and the European Union. It was apparent to me that EU protection of PII, personally identifying information, is much more extensive and effective than in the U.S. More recently, I co-authored an article, Privacy and Security in the Implementation of Health Information Technology, U.S. and EU Compared. Now, we start with the assumption that there will be significant efficiency gains, but there could be some diminution in the privacy of medical records. Let me just provide you with some overall statistics. In some EU countries, 90% plus of their medical records are electronic. In the United States, it is fewer than 50%. And it's also true that in economic parlance, there are significant and positive network externalities associated with making all electronic medical records electronic, so that there is excuse me, an economic justification for subsidizing startup cost. All right. I know I was supposed to confine my remarks to legal, but these things are interspersed. Let me just jump ahead and point out, for example, that HIPAA has over 15 exceptions in which medical information can be transmitted to third parties without patient consent. In the EU, there are only 3 exceptions, which I'd be glad to go into. Let cite a couple quotes and then finish up. There was a recent article in November 2010 in the New England Journal of Medicine in which it was stated, the question is whether EHRs will help providers defend against such claims, medical malpractice and medical liability, or leave them more vulnerable. The answer seems to be it will do both. I'm sure that's reassuring to providers. Compliance with FTC and security protection standards necessitates firms to be cognizant of recent FTC actions, which requires firms to possess substantial expertise in IT. And yet, in my opinion, security breaches are inevitable. An article written by my colleague, Professor Faye Cobb-Payton at NCSU, stated.
And I keep turning my button off. I'm sorry, Dr. Baumer. I am going to stop you there. Your opening statement will be submitted for the record, and I do appreciate that insight regarding all of the security issues that we are faced with.